The Allahabad High Court today made it very clear that that controversial Places of Worship Act 1991 does not bar findings by the Archaeological Survey of India at the Gyanvapi Complex. The court also said whether the disputed structure in Kashi is a temple or a mosque can only be ascertained by evidence that emerges. Justice Rohit Ranjan Agrawal dismissed 5 petitions filed by the Sunni Waqf Board and the Masjid Committee, insisting that the Archaeological Survey of India's survey was as per orders of the court.
Big boost to the Hindu side in the Gyanvapi Mandir versus Mosque case. The Allahabad High Court has rejected all petitions from the Muslim side challenging the Hindu side's plea to worship at the Gyanvapi complex. 3 pleas by Muslim side against an order for ASI survey of the Gyanvapi complex were also rejected. The single judge bench of Justice Rohit Ranjan Agrawal also asked the lower court to complete the hearing on the matter in 6 months. The High Court crucially observed that till the court gives its verdict, the disputed complex cannot be called a temple or a mosque. The Muslim side had been banking on the Places of Worship Act, which bars changing nature of a place of worship and puts a status quo starting 1947.
हर जगह वो ये कहते हैं कि यहाँ हमारे फला देवता थे, लेकिन ये अभी कहीं से साबित नहीं हुआ है। जीपीआर से ज़रूर कराया गया, तो जीपीआर अगर पूरे शहर में चलाया जाए तो हर जगह 40 फुट नीचे बहुत सी चीज़ें स्ट्रक्चर दिखाई पड़ेंगे। अब वो स्ट्रक्चर किस चीज़ का है, कैसा है, अब ये तो सब बहस की बात होगी, बहस का मुद्दा होगा, लेकिन फैसले जो हो रहे हैं वो यूँ समझ लीजिए कि फैसला हो रहा है, इंसाफ नहीं हो रहा है।
The Hindu side maintained that the entire Gyanvapi complex is part of Kashi Vishwanath temple and the mosque was built after raising an ancient temple.
मुस्लिम पक्ष नहीं चाहता कि असलियत सामने आवे, क्योंकि असलियत सामने आ जाएगी तो ये जो तथाकथित मस्जिद है ये हटनी ही पड़ेगी और यहाँ पर भव्य मंदिर बनने का रास्ता साफ हो जाएगा। और मुझे उम्मीद है कि बहुत जल्दी इस केस का फैसला होगा, आज के फैसले के बाद, कि साल 2 साल में बनारस में भव्य मंदिर बनने का रास्ता बिल्कुल साफ होगा।
The verdict came a day after the ASI submitted its scientific survey report on the mosque complex before the Varanasi District Court in a sealed cover. It will be shared with the petitioners on December 21st and a copy will be sent to the Supreme Court. Bureau Report, India Today.
The Allahabad High Court also made it very clear that whether the disputed site is a temple or a mosque will only be ascertained by the court of law on the basis of evidence gathered and submitted. Section 4 of the 1991 Places of Worship Act is not applicable as the religious character is yet to be determined. Has this taken the wind out of the sails of the Masjid Committee and the Waqf Board? And does it also pave the way for other places in times to come? Joining me on this special broadcast is Kapil Madan, an advocate and a political analyst. Desh Ratan Nigam is a lawyer and a political analyst joining me on the broadcast. But my first question is to India Today's Legal Bureau Head, Nalini Sharma. Nalini, Justice Rohit Agrawal's ruling that the Gyanvapi suit is not barred by the Places of Worship Act 1991, is this going to be a turning point in the Kashi case? This verdict, very crucial, Nalini.
Absolutely, Gaurav. There's no doubt about the fact that it's a very significant verdict that has been pronounced by the Allahabad High Court today. And there are a couple of reasons why I say that. Number one, when the Allahabad High Court has said that the suit is not barred by the Places of Worship Act, what it means by that is that the religious character of the disputed site is something that is still yet to be determined. Because the 1991 Act specifically says that any place of worship, the religious character of it cannot be converted. The key word over here being converted in accordance with the Act and it cannot be converted from the status that it was in as of the 15th of August 1947.
Yes.
But what the High Court has said in its order today is that the religious character of this disputed site at the Gyanvapi complex is something that has still not been determined. So unless the court determines what the religious character is, there is no question of its conversion. And that is the reason why the court has also said that this site at this point should not be called either a mosque or a temple.
Very interesting. Let me take this to Kapil Madan then. Kapil Madan, the court order clearly says that the religious character of the disputed place as it existed on the 15th of August 1947 will only be determined by the evidence that's been gathered and submitted. So, sir, that cover of Places of Worship Act has effectively been removed from this court order, sir.
Now, Gaurav, I will, make 2 points here. My first point is I agree with, what Nalini said here, that though conversion is something which is barred under the Places of Worship Act, but determination is not, and I agree with Nalini to that extent. Now, I will make, my argument on the facts of this issue. You may recall what the petitioner are trying to pray. What is the prayer of the petitioner in this case? They are saying they should be allowed to pray at a particular site. Now, my point here is that if after 1947, they were carrying out these prayers, then, this particular suit itself would have not been required, because in that situation, you don't need a court's order for something which you were already doing after 1947. If this practice was not being followed after 1947, then perhaps the provisions of the Places of Worship Act will kick in. But yes, I agree with Nalini here that this needs to be determined.
Okay,
and
let me get Deshratan Nigam to respond. Fair enough, sir. You made a very valid point. But what if, and again, I'm on facts of the case, Nalini with me here, what if that practice of worship was stopped post-1947? And if that was truly the violation of the Places of Worship Act, sir, which is what is going to be established in this case.
Yes.
This is where,
I
sir,
agree with you. I think, yes.
Let me get Deshratan Nigam. The court not only said that this place can neither be called a mosque or a temple, Justice Rohit Ranjan Agrawal also says that a compound can either have a Muslim character or a Hindu character. Sir, the Muslim side, and we played out the reaction, said फैसला तो हो गया, लेकिन इंसाफ नहीं हुआ. Deshratan Nigam responds, sir.
Gaurav, let me tell you one thing. The objective of both substantive law and the procedural law is to find the truth if there is a dispute. And therefore, the scientific surveys, evidence all point out towards finding the true nature of the dispute and also finding the truth behind it. And therefore, commissions are appointed for that purpose. Scientific surveys are done. And it is our national value. If you look at our national emblem, down there it is written Satyameva Jayate. So that is the basic Sanatani civilizational value. One set of people want the truth to come out, other set of people do not want the truth to come out. Even a blind person can feel the truth of the Gyanvapi structure, that it is a temple. However, the courts have made it very clear that let the religious character of the place be determined in the suit, because a declaratory suit as well. Secondly, they said it is not about converting the religious character of the place. It is about determination of the religious character of the place, which has not been defined under the Act. So therefore, it is not barred by Section 4 of the Places of Worship Act 1991.
So let me take this to Nalini, because that's an important point. The court, Nalini, also raised a very pertinent point. What is the definition of a religious character of any place? This itself has not been defined in the Places of Worship Act 1991. This is very clearly open to interpretation on the basis of evidence gathered and submitted before the courts at this point of time. Because, Kapil Madan was saying, if prayers were happening in 1947, this suit would not be required. If prayers were happening in 1947, but were stopped in 1991, who's in violation of the Places of Worship Act then, Nalini?
Gaurav, that's a very interesting point you make, because usually when we talk about the separation of powers, what we say is that it's the job of the legislature to make the laws, the job of the executive to implement the laws, but it's the job of the courts to interpret the laws. So whenever there is something missing in what has been written down, it is the job of the court to read into it and find out exactly what the definition is. So like you said, the Allahabad High Court has very categorically said in its judgment that what a religious character is itself not defined under the Places of Worship Act. So in a situation like this, it falls upon the court to go ahead and first of all interpret what religious character is. And that's precisely the reason why the court has said that this suit is not barred by the Places of Worship Act, because until and unless A, the court defines what religious character is, and then B, applies that definition and decides whether the religious character of the Gyanvapi complex, because, and we're now calling it complex, because the fact that it's been a mosque or a temple is something that the court has left open to interpretation, is something that can only be determined by the court. Now, remember, Gaurav, this is a trial that was stayed back in 1998.
Yes.
And since 1998, the trial has not continued. So that's why this verdict is even more significant, because it's finally given a green light for the trial to go ahead that was stayed way back in 1998. And not just a green light, the court has said in its order that this trial needs to be concluded expeditiously, because this is an issue of national vital importance, is the words that they've used. And they've given a deadline of 6 months to the Varanasi court to conclude this trial. Having said that, there is no doubt about the fact that the Muslim parties will approach the Supreme Court,
Sure.
challenging this Allahabad High Court order. They've already said it in a bite earlier today,
Yes.
that they will fight till their last breath. So it all remains to be seen what the Supreme Court decides before we can take a final word on this.
Oh, absolutely. But as on date, as facts stand as on date, the ASI survey will happen to find facts. The Masjid Committee was opposed to the survey, and their plea stands rejected. The ASI survey, Mr. Madan, was happening on the orders of the court. But Desh Ratan Nigam asks that question, why is it that one side wants facts to come out, the other side does not want even a survey to be conducted, or if a report is submitted, it should be in a sealed cover and facts should not emerge. Mr. Madan, is that fair?
Gaurav, I think, when you look at the arguments made by the other side, the Muslim side, they have primarily raised the point that, the suit is barred by the express provision of the law. And if I would, give a technical term to our viewers, there is a provision under the CPC which we use, which we call Order 7, Rule 11, which is used. Which is used where you want to get the suit out at the initial stages. Now, it's a technical provision. It's a technical provision. This is, rarely the person invoking this provision succeed, because what happens is, in this case, is that the court who's deciding the matter
Yes.
has to look at it only the documents presented by the plaintiff, the person who is seeking a relief from the court, and not any other document. It is again a settled provision of law.
But that that's been
claim,
settled. That's been settled. My point is, respond to Desh Ratan Nigam saying that one side wants facts to emerge. The Muslim side, according to Desh Ratan Nigam, does not even want a survey, an ASI survey, a scientific survey, or when the report is submitted to court, those facts should be made public. In your appreciation, why, sir?
Gaurav, I think I am not representing any of the petitioner or the respondent here. So whatever is the legal strategy adopted, I mean, as a lawyer, you would try and ensure that you win the case, and you win the case as early as possible. And this is one of the legal provision which you had in your prima facie in your favor, which you could have invoked, and you could have won at the initial stages. And Mr. Nigam would agree with me. He's also a lawyer. When you are appearing from the respondent or the defendant side, your strategy is to get the closure, get the plaint rejected at the initial stages. So
Nalini,
it appears to me, a legal strategy. It appears to me a legal strategy that let's win it at the initial stages. Perhaps the court has not found favor with the argument by the Muslim side, and that's the reason why you have an order of where they have.
But the fact still remains, because the Muslim side, why does the Muslim side not want facts to emerge in this case, now that an ASI survey has happened in parts of that Gyanvapi complex? But Nalini, Does this then pave the way for an ASI survey of the Wuzu Khana, where the Hindu side insists there is a shivling and the Muslim side claims it's a fountain? And I want to show those images. The Hindu side says it is a shivling there. The Muslim side says this is a fountain. ASI survey there, will it ascertain facts?
Well, Gaurav, that's a very interesting and tricky question, because the Allahabad High Court verdict today has categorically said that during the course of the trial, if the Varanasi District Court feels that a further survey is required to be conducted for the determination of the facts of the case, then it has the authority to go ahead and do that. But at the same time, this comes with a very big rider, which is not mentioned in the judgment, but which is something we know through the history of this case, as we've seen over the course of the past few years.
Okay.
When the matter had reached the Supreme Court regarding the ASI survey, there is a Supreme Court order in place that had allowed for the scientific survey to happen, but had specifically said that the Wuzu Khana area needs to continue to remain being sealed.
Yes.
So in light of that order already having passed by the Supreme Court, any scientific survey that needs to be conducted has to come only after approval of the Supreme Court. There cannot be any survey that can be conducted in contravention of that order. So there is no doubt about the fact that this matter is eventually going to end up in Supreme Court. So there should not be any additional legal hurdles for there to be a decision on that. But any survey has to be conducted only with the green light being given by the Supreme Court itself.
And that shivling / fountain, Deshratan Nigam, is that the crux of the matter? We've seen the reports of the earlier survey. The current ASI survey, of course, is in a sealed cover. But the initial survey seemed to indicate that this was a shivling. The Muslim side claims it is a fountain. In your appreciation, will there now be a demand that there should be a scientific survey here to establish whether there's a fountain, whether there's any route for water ingress, and not just a hole that was hurriedly made on top subsequently, Mr. Deshratan Nigam?
Gaurav, ultimately, scientific survey has to be taken of this particular Wuzu Khana and the shivling. And even other places also, because there is a lot of mound out there where things are buried, and also under the dome of the alleged mosque, there are enough evidences which are still sealed. And therefore, ultimately, if one wants to unearth the entire truth, I think the scientific survey and the physical survey of the entire complex and each and every structure has to be done, and all scientific techniques that the Archaeological Survey of India applies, whether it is deep penetrative radar images, survey, or physical digging, ultimately that has to be taken. And one day this will happen, because the job of the court is to find the truth.
Okay.
And that can only happen because of the scientific survey and the techniques, undertaken by the Archaeological Survey of India.
Before I bring in Kapil Madan, I want to ask you another question. There are some Muslim leaders who fear this will open up Pandora's box. First, Ayodhya. Now, the quest for the Sri Krishna Janmabhoomi at Mathura and the Kashi Vishwanath temple here in Varanasi. How many other temples will the effort go to retake? Because this is where Muslims say, you're not even permitting us to pray or live with dignity. Mr. Nigam.
Let me tell you, Gaurav, one thing. If a structure is forcibly taken or demolished and a mosque is built over it, it is not a mosque under Islam. And namaz will not be kabuled out there. It is not accepted by Allah. And some of the leaders, religious leaders of Muslims, are trying to make a fool of Muslims, calling it a mosque, knowing very well the Islamic evidence, the Masare Alamgiri of the Aurangzeb, written by the official historian, clearly mentions its demolition, and various other demolitions which have taken place in the past. The evidence is so very well written. Now, if you do not accept this truth and tell your people that it's still a mosque, then you are doing grave injustice to your own people.
Okay.
So this fact needs to be brought out. And secondly, let me tell you, initially the Hindus wanted only 3 places: Ram Mandir, then the Gyanvapi and the Krishna Janmabhoomi. They refused. Otherwise, things could have been sorted out.
Okay.
Today what is happening? We have lakhs of temples in India which have been destroyed. It has given impetus to the people. The local people will pick up the issues. I think it's still time for the Muslim community to come to terms with the reality and the truth and accept the truths that
for the
you
moment,
are in
I
India.
want to stay on the legal point. I will come to the social and political point in just a moment, but I want to stay for the moment on the legal point of the Allahabad High Court order today. And Nalini, will this impact the Mathura case too, where the Hindu side insists the Places of Worship Act 1991 actually works in their favor?
Well, Gaurav, let's not forget that the validity of the Places of Worship Act 1991 is something that itself is in question before the Supreme Court. So if the Places of Worship Act 1991 in itself is found to be unconstitutional, then all of this debate is meaningless. But at the same time, now that this Allahabad High Court verdict has come through that has said that the Places of Worship Act does not bar the debate around Gyanvapi, it remains to be seen how it's going to be interpreted when it comes to the Mathura case and the Shahi Idka and the Krishna Janmabhoomi case, because there is no doubt about the fact that all of these cases will have an impact on each other, because even in today's Allahabad High Court verdict, we've seen the judge has quoted the earlier Ayodhya Ram Mandir case and how the Places of Worship Act was interpreted in that matter. So with every subsequent case, the manner in which the Places of Worship Act is being interpreted is no doubt going to impact any future cases regarding it that come.
Kapil Madan, you wanted to come in. You want to quickly respond to Deshratan Nigam, I believe.
Yeah. So yes, I will respond to Mr. Nigam. Mr. Nigam raised a point. He quoted some historian and said that it is written somewhere that it was a temple and it was demolished and thereafter the
Sir,
mosque
not
was made.
somewhere.
So
not somewhere.
Sir,
it is not somewhere.
I couldn't catch. Mr. Nigam,
let me take it. Let me
okay,
take the
I
name
couldn't catch
again.
it. Okay, please do that. Please do that.
Written by the official historian of Aurangzeb.
Great, thank you. I am not disputing that fact. I couldn't catch the word, so therefore I said you quoted, a source from where you are taking this argument. But if Mr. Ratan's argument is being argued in the court, if Mr. Ratan takes these arguments to the court, then I can assure you that they are going to lose, because the argument that I made in the beginning, that it is the date, that is 1947, that needs to be seen, whether on that date what was the religious character of the place. Now, if Mr. Ratan's argument is accepted that it happened prior to 1947, and I am not either admitting or disputing what Mr. Nigam is saying, I am just taking his argument as he says and applying to the law, the Places of Worship Act, as I mentioned in the beginning. Then in that situation, what he's arguing is basically favoring the Muslim side, that this appears to be barred by the Places of Worship Act.
Okay, you want to quickly respond? Go ahead, sir.
See, the fact is the court itself has today said that they will look into documentary, oral, literary, and all kinds of evidence. So this is a part of literary and oral and documentary evidence I was talking about. So it will be in continuity. What will be seen is in continuity till today, right from that day. So character will not be decided in isolation, but there will be a continuity to it.
Fair enough. Nalini, what next after this order? Its impact on other cases, and is there an apprehension that since several temples were demolished and there is evidence of temples being demolished in Rajasthan and other parts of the country, does it actually open, as some fear, a Pandora's box?
Well, Gaurav, there are going to be long-term repercussions of this order, but at the same time, immediately if we ask what next, then a couple of things come to mind. Number one, like I stated earlier, there is no doubt about the fact that the Muslim parties, the Masjid Committee specifically, is going to challenge this order before the Supreme Court. And every aspect of the Gyanvapi case, I've said this multiple times before on air, every single aspect of this is eventually going to land up in the Supreme Court, and the top court will have to give its seal of approval, because they got into it at the point of the ASI survey itself. Number two, the Allahabad High Court order today has categorically given a 6-month deadline for the trial to be concluded. I told you earlier that this is a trial that was stayed back in 1998. Yes. It started in 1991 and it's not been conducted since then. So it's extremely urgent, and the court has said that it's a case of national vital importance. The court has also said that this is not a suit between two individuals. This is a suit between two very major communities of the country, and which is why it is a case of national vital importance, which is why it needs to be be concluded at the earliest. So we can expect an expeditious trial before the Varanasi court, which probably means on a day-to-day basis, we might be seeing a trial ongoing before the Varanasi court and hopefully see a final verdict in the trial that's been pending since 1991 within the next 6 months.
And Nalini and her team will be tracking that story very, very closely. And we'll get you much more on this. Kapil Madan, Deshratan Nigam and Nalini Sharma for joining me here on this India Today special. Many thanks.